Hey guys, Toby Mathis here, and today we're going to go over 13 things that you do not put in your will. Now, if you've been watching my channel for any length period of time, you know that I would prefer that you use a living trust. There's really three options you have. You could do nothing, in which case you pass away. It's called intestate, and you end up in probate. You could do a will, in which case it's a written document that directs what happens to your assets when you die, and that goes through probate as well. It's like a grease slide right into the court system. Or you do a living trust and you avoid it. But I know a lot of you guys are going to end up doing that will. It's better than nothing. But you got to be careful to not screw yourself up when you do something like putting an estate plan in place like a will. And so today we're going to go over 13 things that you do not put in that will because it's going to cause a problem. And let's dive right on in. Number one, and this is a non-exhaustive list. This is the 13 big ones. There's always some nuances. In fact, put in the comments if you think that I missed one. We'll go over them all. But at the end of the day, what I really care about is that you guys understand why we're just talking about these 13 things. And if you think I missed one, put it down in the comments. All right, number one, funeral arrangements. Why do we not put our funeral arrangements in a will? Quite often, after somebody's passed away, they are doing that will search. They're trying to find it, but it often takes a little while. Some of you guys like to put your stuff in a safety deposit box, and it's 2 or 3 weeks later, right? They finally get into that, and then they go, oh, oops, they wanted to be buried, and we cremated them, right? Make sure that it is somewhere that somebody can get to quickly. I have an emergency binder. In fact, I will put the link, or you could just type in emergency binder in the comments below, and I'll send you a link. So if you just type emergency binder, I will send you a link to a free emergency binder where you can put all of the stuff that you've never, like somebody needs to know, but you probably didn't tell anybody. Like, who are my friends? How do I get into my social media accounts if I'm passed away or incapacitated? Who's my doctor? You know, if I have pets, who's their vet? If I have kids, who are their friends? Like all these things that you wouldn't put into your will, but you still need to document. Just type in emergency binder, and I'll send you a free one so you can organize those things. But in that emergency binder is where you'd put your funeral arrangement, what you would prefer, and make sure that you're letting people know so that they don't have that rude awakening of, shoot, I pull out a will, it's a week later, we cremated mom, and it says clearly she'd prefer to be buried. Don't put that in a will, please. Make sure somebody knows what you want. This is a close kissing cousin to that. Organ donation. Generally speaking, you can get that and put it on your driver's license, but put it somewhere so that someone doesn't have to guess and find out later, because a lot of this stuff, it is instantaneous. Something happens to you, they have to make that decision quickly. You don't want to make a great gift to somebody, but that it doesn't get implemented because nobody knows about it. So make sure that that's not sitting in your will either. That's not where it goes. Make sure that you're reporting if you're in a state that lets it go on your driver's license, or make sure that your power of attorney knows about it. Make sure your family knows your wishes. Even in that emergency binder, you could put it in there, but do not put it in your will, because that will, they're going to get to it too late, and then you won't have been able to make those donations in many cases. So we don't want to undo that great gift by not letting somebody know by putting it in a will. Number three, and this is a big one. See this stuff way too often. It is an IRA, 401k, some sort of retirement plan, 403b, etc. designations. Your will is not your beneficiary. The beneficiary is actually in the plan documents. So if you have an IRA, it's going to say who's the beneficiary. If you have a 401k, it's going to say who the beneficiary is. If you have a 403b, it's going to be who the beneficiary is. You do not put your will. In fact, you could have an unintended consequence of putting in a trust or a will on that designation as the primary beneficiary. Don't do that. We don't switch it into the will. We don't want to also have conflicting provisions. So if you have a beneficiary on your 401k and then you change and you have a different beneficiary in your will, the will is not going to be effective because the beneficiary designation on that 401k is going to control. So you do not put those types of things in your will. You actually do it in the document itself. Now, I have no problem if you're using a living trust to make a living trust a successor beneficiary of an IRA or a 401k, 403b, 457, whatever. You can make it a successor beneficiary, but you do not make it a beneficiary, and you do not make your will a beneficiary. That is not what you do, nor do you put the successor in your will. You want to make sure that these, like, you have the actual documents themselves, the IRA, the 401k, a lot of these are trusts, so you can have a successor beneficiary. Make sure that you're using that, not a will. It can create all sorts of issues. Number 4, end of life decisions. There is something called a living will that a lot of people are aware of, where you make your end of life decisions. Okay, that 100% I'm okay with, but that's not a will. That's not a traditional will. That is not where you put your end of life decisions, because again, chances are somebody's not going to get to this document in time. You're already going to have been passed, then they go find your will, and then they say, oh, you know, I would like to pull the plug or whatnot, and you find out too late. So this is not where that goes. You actually have an advance directive or a living will where you put your end of life decisions, and that's where, hey, don't preserve my life using extraordinary measures. If I'm going to go, let me go, or you use your best judgment, meet with my doctor. I don't want to be kept around for just using up all the estate, draining it just by keeping me in a vegetated state for a long period of time, right? Allow me to go on my terms, but it has to be in writing, and it's going to be in a living will, not in your traditional will. So we want to make sure that. Number 5. Conflicts with living trust. Similar to what's going on with the IRA and the 401k, you do not want to have a living trust and a will where there's different beneficiaries. If you have a living trust, you still have a will, but the sole beneficiary is the living trust. That way you never have a conflict. It says distribute under the terms of the living trust. If I have a will and I have a living trust and I have, hey, my boat goes to, my son, and then in the other one it says it goes to my buddy, we have a conflict and you're creating issues and you're going to have a problem, right? So you want to make sure. Chances are, under those circumstances, the will's not going to work because there's nothing in the estate if it's already been transferred in the living trust. Or if you never transfer the boat in the living trust, then it's going to be covered under here, right? You're going to have a mess is what you're going to have. And you're going to have probably a legal dispute of people arguing over who actually gets it. So please do not have a will where you're distributing up the estate and a living trust where you're distributing up the estate. What you have is a living trust and a will that pours into the living trust. You never have provisions in both. You make sure that you have that living trust, and then the pour-over will makes the living trust the beneficiary. Do not have conflict with your living trust. Here's another one, and we see this all the time. Assets held in another entity. I'm going to have to get a bigger board, guys. Assets held in another entity. What does that mean? It means, let's say that I have an LLC, and that LLC owns a rental property. Maybe it's 123 Main Street. And I give the LLC to my kids. And then I put in my will, I want to give the piece of real estate, and I name it, to somebody else. Maybe I give it to, my business partner. Okay, now we have a mess, right? I gave the business itself that owns the asset to somebody else, which means that asset went with them. And then if I try to give the asset away to somebody else, I'm making a mess. And A, it's not going to be effective, and B, you're creating a ripe dispute, like you're going to have people fighting as a result. So you do not give assets. Another example is if you have a corporation or whatnot and it has a fleet of, maybe it has some equipment. Don't list that equipment in your will. You don't own it. The entity does. If you're going to give anything, it's going to be the interest in the entity. I might give, for example, if I have a corporation and it's got a bunch of equipment and it's got a bunch of money and a bunch of assets and some intellectual property and blah, blah, right? I'll give the shares to somebody. Or if it's an LLC, I'll give the membership interest to somebody via my will, but I will not give the underlying assets held in that entity because I don't have to do it, and it's going to create a conflict if you do. So you want to make sure that if you have assets held in an entity, and again, it could be rental property in an LLC, give the LLC, don't put that rental property on your will. It's going to create a problem. Number 7, do not leave reasons. Do not explain yourself in your will. Do not say, gosh darn it, but my kid, they just didn't come visit me enough, so I'm not giving them something, but my neighbor always showed up, so I gave them all the fishing rods, right? You're just going to, you're going to create bitterness. You're creating drama where it doesn't need to exist. You do not put the reasons why you're giving things away. You just give it away. You don't have to do it, but otherwise you're going to cause problems. And you open yourself up to disputes. For example, if you have 3 kids and you say, hey, this kid was always really great to me, and these other 2, they didn't visit me as much at the end, you're going to open yourself up to undue influence and all sorts of stuff. Where they're going to start fighting with each other, or you're just going to make people feel like crap. Let's not do that. Let's make sure that we keep that private because let's just be real. A will is filed as a public document. Anybody can go read it, which means, oh, crud, somebody can go look at everything that you are writing up here, and I can go read about it. So if you want to have your family drama, it's now out there in the whole world can see it. So don't do that. Number 8, pets. This one is near and dear to my heart because I have 2 kitties. They can't own things, guys. So you could always say, like, I'm going to leave my estate or whatever to my pets. Don't do that. Right? There has to be somebody who could actually have legal title. It's like kids, right? I could leave it to kids, but you're gonna have to have somebody else involved. If you want to take care of your pets, leave something to somebody, usually in trust. You can create a pet trust, but let's just say, hey, I want somebody to take care of my pets. I will leave them the pets, and I will leave them some money so that they can care for those pets. What I will not do is leave the pet, like, here, I'm gonna leave my house to my pet. Don't do that. No bueno, right? You want to make sure that you are doing things that are legally recognizable. So as much as you'd love to be able to say, hey, I want to leave all my assets to my kitty, don't. Create a trust where those assets can be held for the benefit of the kitty, where somebody's watching over it, and then there's distributions after the cat is gone. Like, you can do that, but don't just do crazy things like say, I'm just leaving everything to my cat. Now, I get some of you guys are true, they're your children. I get it, but you still got to do things legally so that it's recognizable. So you don't want to create a mess that way. What's number 9? Number 9, let's do, all right, I'll move over here so you can actually read that. Life insurance and annuities. Make sure that you are not making your will the owner of the policy or the beneficiary of the policy. Like, technically, we could create, again, a successor beneficiary or make a living trust or something a beneficiary, a successor beneficiary in our policy, but do not have the sole beneficiary be the will, or just put it in there. You will. It literally, if I have a life insurance policy, and I have, let's say that my wife is the beneficiary, and then the successor beneficiary is my daughter, and I put in my will, I want to leave that life insurance to charity. It doesn't matter what I put in the will because it's already covered underneath that policy. So there's going to be a conflict, and I'm opening myself up to problems again. These things are designed to have beneficiaries. Now, could you put a successor beneficiary provision that's a catch-all? Yes, but don't just go ahead and start putting in things that conflict with your will. Like you could say, and again, I'm a big fan of using a living trust. My living trust is my successor beneficiary after my spouse, for example. I could do that so I could put controls over the money so I don't just dump a bunch of money on my kids, right? I could do that, but what I don't want is to have beneficiaries here and beneficiaries underneath my will that conflict, because it's going to create a problem. So the best route is to use the life insurance provisions and then to use a catch-all. And it could be that as distributed underneath my last will and testament. You could put that in there, but that's a successor, right? We want to make sure that we are recognizing that that is what we're doing and that we don't put something that conflicts in the life insurance or annuity versus in the will. So I just want to make sure that we're clear on that you don't want to create conflicting provisions. I know I've said that on a couple of these, but it happens, and so I'm going to just point out the most obvious is things like where there's a beneficiary, life insurance, IRAs, 401ks, 403bs, 457s, annuities, all these things. You want to make sure that you don't have a bunch of conflicts. And it could happen even on having like, hey, I have a joint account, and then I list it in here. I have a joint account with rider survivorship. It's not even something that I can distribute, but I put it in my will, not realizing, wait a second, it's not even my asset. Same thing with the LLC, where I'm giving away a piece of rental property, but I don't even own it because the LLC owns it, right? All these things create conflict, which is why you work with a professional to make sure that they don't happen. Next one, conditions. So if you want to put conditions like, hey, so-and-so is to receive this, but only if they graduate from college with a 4-year degree, only if they're married, if I'm putting in provisions, or only when they're 25, all these things, do not do that in your will. Use a living trust for that. When you put conditions, you create muddied waters all over this thing, because a will is a die and distribute. I could create a testamentary trust out of this thing that says, hey, I will create a trust when I die, kind of like Michael Jackson did. You can see how that works, but not a good idea. Now, if you want to put conditions, go with the living trust, right? Just do it. Don't make messes. If you want to put conditions on your gifts, and the most obvious is you could create, like, if I want to put something in that restricts somebody's ability to access monies if they're under certain circumstances, like if they're incapacitated, if they're drinking, if they're doing drugs and things, I need to have a trustee making those decisions. I do not want to bring it into a probate court because it's going to be prohibitively expensive. It's not what it's designed to do, and it's not going to get you the result that you're seeking to achieve. Do that through a living trust. Do not try to do that through your will. Now, you could, again, have a pour-over will that dumps everything into your living trust. Or you could create what's called a testamentary trust, which means the will says we're creating a trust with these provisions in it, and then it flows into the trust. That's not my favorite because you're still probating the heck out of it, and I'd prefer to avoid the probate if I can because it's so expensive and time-consuming in most jurisdictions. So I'm going to say go with the living trust if you have conditions. Do not try to do it in a will. You want to make sure. Other fun stuff that you do not want to have in a will is, let's just put private info. This is a public doc. I want to make sure you understand it's a public document. If you put things like passwords, if you put things like account numbers, all those things in, you could end up getting in where there's issues. So if you put bank account number with a password and all that stuff, it could end up being in a public record, guys. We do not want to tempt fate. Now, some courts will say, hey, let's file this and we'll do some redaction or put it under seal and try to, but now you're talking about lots of added complexity and cost that didn't need to happen. Don't put your private information in a public document, right? You're just inviting all sorts of issues. So please don't do that. Here's another one, and I'll just put this down here as number 12. Sole props. I'm not a big fan of sole proprietorships because they tend to get audited at about 800% of what other, like a S Corp gets audited or a partnership. They lose their audits. But even more importantly, if you're a sole proprietorship, which is an active business, and you pass away and it's going into the probate court, it's toast. It's done. It's not going to make it. It's going to be shut down. Similar things happened when you're actively trading a stock account, for example. Then you go in through the probate process and you're going to be frozen. Your options are going to expire worthless. You're going to end up losing out on monies. And this happens over and over again. Talk to your brokers about it, about what happens when people pass away, what they can do and what they're not allowed to do. You have something that's active, an active business or an active investment strategy, and you're doing it in your name, do not put that in a will. Do not have that go through probate because you're going to kill whatever that is. That is just absolutely what you don't want to do because you're going to end up destroying whatever that business was. There's just not a situation where a sole proprietorship makes it through a probate and out the other side. The assets are going to be distributed, right? Because you did not recognize that as a separate business. The court won't recognize that as a separate business. They'll recognize it as your assets, and they're distributing it under here, which means the business goes bye-bye. It's not going to make it. It's going to end up killing your business. It's going to be killing your investment strategy. And the last one, and I'll just leave this, is I mentioned it earlier, joint assets, paid on death, transfer on death. See if I could actually write it in there. Paid on death, transfer on death. Anything where you're already specifying who the beneficiary is, like on a bank account or on a piece of real estate, on a car, don't put those assets in your will as well, because now you're just asking for trouble. What's an example? Mom and dad passes away, mom's there, sister ends up, or daughter, so let's say there's 3 kids, 2 brothers and a sister, and sister takes care of mom. Mom puts sister on bank account as a joint owner on the account, saying, all right, you're on the account. It's a $500,000 account. And then mom in her will says, divide the account up when I pass. Problem with that. Soon as mom passes, it's a joint asset with her daughter. Daughter now inherits the entire $500,000. Brothers are saying, but there's a will that says that I'm an owner of part of that. Too bad. The will in the estate no longer owns that asset because it was jointly held with somebody else. And so it went to sister. And we see it all the time. There's always disputes. Somebody does this. Moms, certain groups love to put their oldest child on all their real estate and all their bank accounts. And then you're like, okay, you just did a gift to them, right? We have tax implications to doing that. You just nixed all your other kids because they are on it. You're not going to get a step up in basis. Like there's all sorts, you're liable if they go bankrupt, they're going to take those assets. If they get sued, they're going to take those assets. There's all sorts of bad things that happen when you put your kid on your piece of real estate or on your account. And this is sometimes what ends up happening. Hey, I'm going to do a paid on death and I'll have it go to my, to one of my kids. And then you just nixed your other kids. They are now disinherited. They don't own that asset anymore. Whoever you listed now owns that asset. Sometimes they do it during your lifetime when you have joint assets. Sometimes you do it after where you have a paid on death or a transfer on death. Don't do that where it conflicts with your will. So there's 13. Guys, I said earlier, you can get that free emergency binder. Just go down in the comments and put emergency binder. If you think I missed anything, put it down in the comments. If you know anybody who could benefit from this information, please share it with them, especially Maybe it's your parents, maybe it's your aunt and uncle, maybe it's somebody that you know that did one of these wills, and you just said, hey, just make sure that you're not creating a mess, because a mess with a will goes into court, and that's what we don't want. We want to avoid court. So I'm going to say it again. I'd rather you do a living trust. Reach out to us if you want to learn more. Otherwise, just put down below emergency binder, or give me your comments and your thoughts to this video. Like and subscribe, and I'll see you guys later.